Hello, my beautiful friends. It is an amazing day. We've got some good business to attend to on the stream. I'm grateful that you're here and with us. I hope your week and your Tuesday are both unfolding oh so beautifully. Today, we got some Fani Willis business. Bunch of drama in Fannyland today. We're going to talk about it because we got a big one from Judicial Watch that just dropped fresh out of the oven saying that Fani Willis owes Judicial Watch some court records, and there's some pretty important court records there. And she's got 5 days and counting to get those records over to Tom Fitton, and we're going to be excited to see what's inside those records. But we'll go through the new order that came out. You can see fresh out of the oven, Judicial Watch versus Fani Willis. That's coming up. And these are the J6 records, the Jack Smith records. Her collusion, her own racketeering and conspiracy against President Trump. We're excited to read that one. Then we'll see what else happened in Fulton County and in Fannyville, because boy, oh boy, man, she lost another one. Totally embarrassed as she lost her trials in the YSL case, the Young Thug case. Yak Gotti acquitted on murder, racketeering, and other gang-related charges. Wow. And so she just loses again. Man, she's terrible at her job. And there's some questions about what is coming next for Fani. We know that while she had these people in custody who were all acquitted on the most serious charges, they got stabbed. It's not funny, actually. We know that people were eaten alive by bed bugs in her infested jails. And we also know that the families are all celebrating. I mean, this has been going on for years. And it has been the disgusting government breathing down the necks of innocent people because Fani had a political axe to grind. Now, Fani was also in court today because she's fighting a subpoena that has come out from Fulton County. The Senate committee actually came out of Georgia and said, Fani, you better show up here. Bring your big Fani down here and sit down and answer our questions. And so I've got an exchange on what took place today in court. This is a gentleman fighting to enforce the subpoena against Fani. They delivered her a subpoena, and so she appealed that. And so we're there making this argument here today. So we'll see what that looks like. But Fani had a rough day. So two big stories out of Fulton County in Georgia that we'll attend to coming up. Then we'll see what's the latest with the Biden pardon, because he has now lost his final battle. Yesterday, we broke down the distinction between a dismissal of the indictment and a termination of the case. Well, today, Judge Norika from Delaware gave us the final order, and we get to decide what happened. So she'll tell us what is coming, what happened there. This was Hunter's response. Remember yesterday that the prosecutors, the DOJ, were telling us that they do not want this case to be dismissed as the disposition, as the resolution of the case. They want the case to be terminated. And so this was Hunter and his people saying, no, it should be dismissed. You have to dismiss it because my daddy is the president. Now, meanwhile, Joe Biden was in Angola for whatever reason, in Angola, being dragged around by the Angolan president, doing what he does there. And then we've got in our final segment an Elon update because, man, this judge out of Delaware is insane and has now robbed him of a $50 billion super chat, which is a big one. I don't even think YouTube goes that high, but it's a lot. And so we'll go through the opinion that came down from this judge. You can see it's 108 pages. I'll show you the highlights, but Elon and his team are vowing to fight back, and we're excited about it. We'll see what the New York Times says the next steps are, but I do have the opinion pulled up. And get this, I came across this other article. The lawyers who were suing Elon, you know how much money they're making an hour based on this settlement? $17,692.31 an hour. Wow. That's an expensive lawyer. So it's just rigged. Anyways, we'll come back to all of it, my friends. I'm glad that you're here. I hope your week is unfolding so astoundingly well that you can't even hardly speak like me. But we've got business to attend to today, and so let's start back at the top. It's great to have you here. Let's see what's happening out in Fani land. So to zoom in on what we just outlined, let's get to it. Fani Willis now ordered to turn over certain documents. Big congratulations to Judicial Watch, who delivered to us this order out of Fulton County Superior Court from a judge we've heard of before. His name is Robert McBurney. We read some of his decisions here, and in many ways, he was allowing, in my opinion, Fani Willis and her office to get ahead and do bad things before this opinion came out, where he is slapping her and her office pretty substantially, as we'll see. So what changed? What caused the sudden flip? Is Fani now suddenly going to be under scrutiny since she's lost the YSL case? The Trump prosecution RICO case is probably dead on arrival at the Court of Appeals. And now she's going to have to turn over certain documents to Judicial Watch that might involve Jack Smith and other things. She's having a bad time there because she's not a good attorney or qualified it for this position. But Fulton County and the people of Georgia reelected her this last election. She'll be there for a while. But here's the background on what she is going to have to give to Judicial Watch. They say that they find her in default, meaning she just ignored the orders from the court. She didn't show up, didn't file a response, so you lose by default. It's almost malpractice. Some people might say it is malpractice because she's a prosecutor in this case. You can default by accident. Honestly, I didn't get the thing in the mail. I defaulted. Sorry, can I remove the default and reinstate the thing? Yes, okay, no problem. We understand there's oversight. But she's a prosecutor's office. You don't get to just ignore court orders. So there was an open records lawsuit brought by Judicial Watch, and now the judge is saying, you got 5 days, Fani. Okay, we've dragged this on long enough. Judicial Watch announced today that Fulton County Superior Court judge entered an order that we're going to read coming up, granting a motion for a default judgment against Fani in our lawsuit, Judicial Watch's, against Fani for communications that she had with Jack Smith and the Liz Cheney House January 6th committee. Oh, those are good documents. We want those. In doing so, the court grants Judicial Watch's request for attorney's fees, and I think they're going to have a hearing on that. So Fani might have to call Nathan and be like, yo, baby, hey, remember that $700,000 that you and I grifted off the Fulton County people and the taxpayers of Georgia? Gonna need some of that back. So in doing so, the court grants the request for attorney's fees and orders Fani to search for and to provide releasable records to Judicial Watch within 5 business days. Now, here's the background. In March 2024, not too long ago, a lawsuit was filed against Fani and Fulton County after Willis and the county denied having any records in response to a Freedom of Information Act request. Judicial Watch sued Fani, saying Fani's representation that they don't have any records about this is false. Why? Because the House Judiciary Committee, called Jim Jordan, sent a letter that said they found records. He says that Willis cites a letter from Benny Thompson. Oh, so Fani Willis was talking with Benny Thompson, who is the chairman, so-called. Liz Cheney was really running the show there. She's like, oh, Benny, we'll just put you up top so I don't get criticized. And then I can say anybody who criticizes us is racist. So they put him up top there. But Liz was really running the show. In that letter, Willis requested assistance from the committee and offered to travel to Washington, D.C. Oh, no. So the letter shows us that there were, in fact, communications. This is signed off on here by Jim Jordan. And here's what the letter says. It's from Fani land. Dun, dun, dun. You can see she signed the bottom of this document. Here at the bottom says, yours in service, Fani Willis. That was sent to Benny Thompson. Oh, December 17, 2021, from the office of Fulton County. Says, Dear Chairman Thompson, as you may be aware, I'm conducting a criminal investigation into Trump. Through news reports and other things, I know that your committee has interviewed witnesses relevant to our investigation, and me and my boyfriend want to come to D.C. and have some of those hors d'oeuvres that you have with Kamala. We understand from the same reports that your committee investigators may have collected records relevant to our investigation. Maybe you can leave them by the buffet. Please accept this letter as an official request for me for access to records and to the after party that may be relevant to our criminal investigation. Those records include, but are not limited to, transcripts, depots, electronics, and other records of travel. It may be most efficient for your staff and effective for our understanding for my staff and me to meet with your investigators in person. Like on a cruise? We are able to travel to Washington and stay at some hotel you'll put us up in with massages anytime between January and February. We'll do our best to accommodate the schedule of the committee. So just let us know. Nathan and I want to get out of town. Thank you for your consideration. You may contact me directly via my personal cell phone and email at that address and that address. Should she give him her personal email too? That's curious. Why is it personal? Why not her business cell phone? Interesting. And via email. Was that her personal email or her business email? I don't know. My deputy executive assistant, so-and-so, may be reached at that number and via email at that address. Are those FultonCounty.org addresses or are those her personal emails? I don't know. We know that Hillary used her personal emails, so maybe she was following in the Hillary model. But Jim Jordan says, look, I know you two were talking to each other, okay? We know it. You know it. And so we want the records. And they sued, and Fani ignored everything. And so the court came down and issued an order. And if you want to read more about who Judicial Watch is, what they are, who they are, what they do, well, you can read this book called Rights and Freedoms in Peril, courtesy of Tom Fitton. Why don't this pop out? Boom! There it is. Rights and Freedoms in Peril, courtesy of Tom Fitton, Judicial Watch. Looks like an outstanding read. Can't wait to read it. So check that out. Go to judicialwatch.org. They're doing amazing work. Obviously, we appreciate them bringing us this report. So here is the letter that Jim Jordan sent back almost a year ago to the day. Isn't that fun? How that works. Then we see this is the order. Fani Willis crushed, now losing the motion for a default judgment, which means Judicial Watch wins by default because Fani didn't show up. And what's curious about this opinion is Robert McBurney, the judge, who has previously written some rulings that we were scoffing at here. Like, what? You're just going to allow them to do that over there? And they did it. Now is suddenly changing his tune. And you'll notice the tone of this order is a lot different than we've seen from him historically speaking. He is not happy with Fani Willis at all, nor should he be. But I'm curious as to why maybe the tone has changed a bit. Is it because the election is now over and we can speak frankly? Let's see. He writes, out of the Superior Court of Fulton County, Judicial Watch sued Fani Willis in her official capacity for not responding to any record requests about her clear conversations with the J6 committee. She wrote Benny Thompson and said, I'm packing my overnight bag right now. Writes, on August 22nd, 2023, Judicial Watch, heroes, Tom Fitton and crew, submitted an open records request to defendant Big Fani in Georgia. They sought all documents and communications sent to, received from, or anything related to Jack Smith, who is not a real boy, and all documents and communications sent to the House January 6th committee. Now, what happened is Judicial Watch got a response the next day. The open records custodian named Kay Burwell, who is in the office of the county attorney, which is Fani land, stated that Fani did not have the responsive records. Next day, you file your request. I'd like a request for all these documents. You get an email the next morning. Don't have any. Did you look? Because it doesn't seem like you looked, because you sent an email without checking with everybody in your office. So then Judicial Watch said, oh, okay, well, you don't have anything? All right, we're going to file a suit. So on March 5th, they alleged that Fani violated the Open Records Act. She clearly has the documents because Congress released them. She sent letters and they told us they don't have anything. She clearly has them. Now, because Fani does in fact have responsive records that should have been produced. And so now Judicial Watch seeks the records and attorney's fees. Fani, Plaintiff's request also extended to employees of Smith and the committee. So if anybody from Fani's office talked to anybody else, not just Jack Smith or Liz Cheney, we want that. So it's a broad request. And Fulton County was originally named as a defendant, but they dismissed that and they just focused on Fani. Here's what the judge says. All right, look, it is undisputed that Fani Willis was properly and sufficiently served on March 11th of this year. All right, now they're challenging service, saying we don't have to respond to this. We're not in default. They didn't give us proper process, and because they didn't serve us, we don't have to respond. Judge says, yeah, you were. Hello. They say Judicial Watch filed the return of service 2 days later on March 13th. So when you go and serve somebody, the process server actually serves them, and then they come back and they fill out an affidavit. I did this, this location, this guy was, this male, white male, this location, this address. I walked up, approached him, confirmed, are you Robert Govea? Yeah, I am, okay. And they submit that to the court. So he clarifies in the affidavit, yeah, service happened on March 11th, filed it 2 days later. Now, for reasons unknown to the court, the return did not appear on the court's electronic docket when it was filed and processed. How'd that happen? Was Fani Willis back there in the server room? Was Nathan Wade back there? Did he have on that little janitor's outfit, put on a mustache, grab a mop, go back into the server room? Need to access the files for a second? I don't know. Service never made it onto the docket. Very convenient. When it was filed and processed. And so on April 15th, okay, the court, believing that Fani had not been served because the service was completed, it was effectuated, like it actually happened. The affidavit was there, but the court's, they did not think that Fani got served. So they entered an order directing Judicial Watch to serve Big Fani. They said, well, we haven't served her yet, so she doesn't have to respond. So, and the court, it sounds like they just set like a tickler, just a calendar, okay? If there's not service by this date, then we're going to move this to the inactive case docket and we'll move to dismiss Judicial Watch's complaint. But before they do that, they give Judicial Watch a notice to cure this. Can you go serve her? They said, what? Serve Fani? We already did. Hello. So Judicial Watch responded to the court's order to serve her the same day. They just said, like again? Here you go. We did it already. They called the clerk. Like, what are you talking about? We have it right here. We submitted it a month ago. No, we don't have it on file. You don't? I have a stamped copy. Let me send it to you. So then they refiled the return showing that, yeah, Fani was served on March 11th. So there you go. Whoever went into the server room, Nathan Wade, whoever was in there deleting files, didn't work. So they refiled it. Then Judicial Watch moved for a default judgment on April 30th. They say, okay, Your Honor, look, all the time has elapsed. They had enough time to respond, and they have not responded by April 30th. So then that was filed. Then the judge notes, he says, okay, then suddenly Fani Willis made her first appearance in the case 2 weeks later on May 15th with an answer and a response opposing the motion for a default judgment. Fani says, you can't enter a default against me. Now, Fani concedes that she was served. She says, I was actually served, okay, but reasonably claims that she was unaware that Judicial Watch had filed the affidavit on March 13th. Why? Because it wasn't on the docket. She's like, well, I didn't see it on there. She's like, nice job, baby. You got it off there. But then she argues that she relied on the court's April 15th order directing Judicial Watch to serve her. So she said, now, by the way, she already knows she was served. Okay. But I didn't see that there was proof of the service on the docket. So I didn't respond. And then I saw your order in April saying to serve me. And so that's why I didn't respond. And I did not immediately file an answer because her quote, my understanding was that service had not been perfected. It's like, Fani, you got served. So then Fani further argues, says, well, I didn't know. It's not on your docket. So she's blaming the court. The court's not going to like that either. The court's going to say, well, you're a prosecutor, okay? Did you guys get served or not? Prosecutor Fani further argues that the court's order required the plaintiff to serve her again, required Judicial Watch to go do it again. He's like, no, you don't have to do that again. He just submitted the affidavit. Now, saying you ordered him to serve us again, he only filed the paperwork. So, since he hasn't served us, I'm not required to answer anything, the judge notes, despite answering it now. And so, alternatively, Fani says that even if Judicial Watch's second filing of the second service complied with the court's order, her May 15th answer was timely anyways, pursuant to the law, since it was filed within 30 days of the filing of the second return, which hasn't happened yet. Or the second filing of the affidavit, which was just saying we already filed it 30 days before. So this is Fani like scrambling. Okay, I had no idea. Then you said this, you submitted it, and I didn't know. So I was going off that order. And I'm just totally confused and incompetent. I can't figure this out. Now, she knows what's going on. She's just trying to find a reason why she doesn't have to respond to this, because she doesn't want to turn those records over. Probably because there's a bunch of bad stuff in there. Now, plaintiff replied, this is Judicial Watch, and they moved to strike Fani's answer. They said, no, sorry, Fani, you can't make any of those claims. They say Fani's answer was due on April 10th. So you're expired. Like, it's too late. There are deadlines for a reason. You're a prosecutor. You know how they work. If we filed a motion and there was a timeline that was in your favor that we violated, you, of course, would be pounding the table over that. So you have to respond. The timeline under Georgia law says that. And since you acknowledge that you were properly served on March 11th, you got 30 days. You're expired in April. Judicial Watch also says that to the extent that Fani relied on the April 15th order or her monitoring of the electronic docket, she did so at her own peril. That was her fault. She could have called the court and asked. Plaintiff also points out that Fani has never moved to open a default or paid any costs associated with any of this, as is customary. The law says a defendant shall serve his answer within 30 days. So Fani has 30 days after service of the summons to respond. She didn't do it. Now the judge, having laid that out for us, gives us the order as follows. Says the court finds that Big Fani Willis of Georgia is in default and has been in default since April 11th. As already mentioned, it is undisputed that Fani was served on March 11th and that Judicial Watch filed the return of service on March 13th. Now, while it is true that the return did not immediately appear on the court's electronic docket, this delay does not change the fact that the Judicial Watch team actually filed it, and it was stamped as received by the clerk on March 13th, 2024, which is why we stamp things. So oftentimes you'll see lawyers will come to the courts with multiple copies of whatever they're filing, and they'll get the stamp on multiple copies. So one, they stamp it, file it with the court. One, they stamp it, bring it back for their records. So when the court says, we never got that, you say, yeah, you do. I stamped it. I brought it. I was looking right across the aisle at you. You stamped it. It's here. So they know that. Judicial Watch had it. They said, we filed it. It's here. Sorry you lost it. But because the return was filed within 5 days of service, right? So Fani got served on the 11th. They served it on the 13th. It was valid. That means that Fani was required to answer within 30 days of service, which would have been on April 10th. Nothing in the court's April 15th order changes that analysis. In fact, in its order, McBurney, saying this against Fani, says, the court, laboring under the mistaken impression that service had not yet been effected, simply directed Judicial Watch to serve Fani. But Judicial Watch had already done so, and they've already provided proof of that fact, and they included the return, which is the affidavit, the receipt. So there was no such requirement, says the judge, for Judicial Watch to reserve Fani. What? And the order cannot be read as such, Fani. So she's trying to exploit the judge's, or really the court's mistake. They didn't have the paperwork. It's on them. And she's blaming the judge. And now he's like, I'm not taking that. No. lest any of this appear to be unfair to Fani, who arguably was without notice that Judicial Watch had filed the return of service on March 13th until April 15th, when the Judicial Watch team filed it again, and the clerk caused the original March 13th filing to come back on the docket, so there's now 2 files. Fani could have well opened her default as a matter of right on April 15th. Just says, oh, well, that was a mistake. I see the mistake. Thanks for clarifying. So now let me reopen this without any consequence, as she remained well within the 15-day grace period that's established by Georgia law, but she didn't. Moreover, even had she delayed and filed her motion to open the default outside the 15-day statutory grace period, Fani would have had a compelling case for opening her default on any of the 3 statutory grounds. Providential cause, okay? I didn't do it. Fani's like, it's not my fault that there's a default. I didn't ignore you. No, the clerk had an inexplicable failure to timely post the return of service. She could have said that. She could have said that it was a neglect, but it was excusable because Fani had a reasonable excuse for not answering within the initial 30-day windows because she couldn't prove that there was proof of service on the docket. Or she could have said that a default was being introduced in an improper manner, saying the injustice of denying Fani the ability to open her case would have been the cause of a clerk error, not her own. But none of that happened. Fani could have opened this default or requested to open a default at any time, but she didn't. She did none of that. None in italics. Woo. And this judge says she never moved to open default on any basis, not even during the period when she could have opened the default as a matter of right. Like, we just have to let you open it. You don't have to justify it. We just do it. She never paid costs. She never offered up a meritorious defense at all. And when we talk about costs, the idea is you can think about defaults often. They happen very often in traffic tickets. People get a traffic ticket. They get the ticket. They go home. They forget about it. Then they get a notice from the MVD that their license is suspended. Oh, you missed your court date. You're supposed to show up or pay it or take a driving class or whatever. You lose your case automatically by default because you missed your court date. They suspend your license. Your fine typically doubles. You got to pay it off. Those are the costs. If you want to reopen your case, let's say you have a good reason for why you defaulted, something happened, you reopen your case, you still got to pay the costs associated, and they hold that money in bond while the case is reopened because you've already lost by default. They're just allowing you to process it forward. But she never did any of that at any point to cover the costs to get the case out of default. Never even provided a defense. All right. And like that would be insane. Even in a traffic case, you would say, well, you know, the reason I missed my court date is because my mom was in an accident somewhere else. I could have missed it. It's an oversight or whatever. But it's inexplicable for a prosecutor's office to be practicing this way. Now, they say Judicial Watch is thus entitled to judgment by default, as if every item and paragraph of the complaint were supported by proper and sufficient evidence. Whoo, man, shout out to Judicial Watch. Here, this means that Judicial Watch has established that Fani Willis violated the ORA, the Open Records Act, by failing to either turn over the responsive records or else notify Judicial Watch of Fani's decision to withhold some or all of the records. And here's what Judicial Watch wants. The following relief: a declaration that Fani violated the records laws, an order for Fani to search for all records responsive to Judicial Watch's request without further delay, an injunction ordering Fani to cease withholding non-exempt public records that are responsive to our request. They want an award of attorney's fees and costs associated with this case, a writ of mandamus ordering Fani to provide the requested records, and any other relief that the court deems proper. Now, by finding Fani in default, the court says, we have in effect declared that she has violated the Open Records Act, The court also hereby orders Fani to conduct a diligent search of her records for responsive materials within 5 business days of the entry of this order. Man, you thought those shred trucks at the Justice Department were bad? You thought that they were breaking circuit breakers with all those shredders all over the place? You know what's happening in Fulton County right now? Oh my gosh. Somebody should go check the building. They're shredding and burning and torching everything. It's like a wildfire went off over there. Within that same 5-day period, they say Fani is ordered to provide Judicial Watch with copies of all responsive records that are not legally exempted or accepted from disclosure. If Fani is required or decides to withhold all or part of a request, Fani should follow the procedures set forth in the law. If the records are stored electronically, they may be produced electronically in a commonly used format like PDF. The court, which is perfect because we like to review those on the show. It's very convenient for us. We'll take it. The court expects that such production will include the correspondence identified by Judicial Watch in its complaint. If it does not, Fani is further ordered to explain yourself as to why such correspondence does not exist in your records or why it's being withheld. Now, beyond that, no other relief, injunctive or otherwise, is necessary at this time to include striking the answer, which is of no effect based on the court's finding of default. So, Fani, your answer is not even accepted. That's how embarrassing this is. It's malpractice. I mean, what she has done is, if she were representing a private client and your client got a default, and then in order to try to set aside the default, you angered the judge and you lost the whole case. Not good. A hearing on Judicial Watch's request for attorney's fees and costs is set for December 20th at 10 a.m. Perfect for the Christmas season. We hope Judicial Watch gets a big fat Christmas present from Faniland to the tune of attorney's fees, which I'm sure were enormous in this case. I can't even imagine. I mean, a lot, let's just say. If the parties want the matter taken down, they must retain a court reporter, and the court does not provide a court reporter for civil proceedings. Are they going to live stream it? I mean, please, can you live stream it, please? Please? So here you can see, here was the affidavit of service. The guy's like, yeah, I served everybody. Oh, he served Fani. Okay, so here's the affidavit that I was explaining earlier. It says, all right, in Superior Court, Fulton County, you see this got stamped by the court March 13, 2024, 4:55 p.m. Woo, nick of time. The affidavit of service, Judicial Watch versus Fani Willis. They say, I, Danny Davidson, what's up, Danny D? Great job on this. Says, I personally appeared before me. This is his affidavit. I did this, right? I am appointed to serve process. So here's what he says. I served Fani Willis herself with a summons and exhibits by leaving the documents. Oh, didn't serve her with Tia Green. All right. Her office, her assistant at the place of business. So says, yep, Tia Green got the documents. Fani was probably in the break room with Nathan, and he served her 3rd floor, Pryor Street, Atlanta, Georgia, March 11th at 1:12 p.m. Description of the person that this was left with. Tia Green is an African-American woman with black hair, age 30 to 40, 5'7", weight 140. Signed by Danny Davidson, confirmed by a notary public. So there you go. Fani, you got served, and now you've got 5 days to get the documents back over to Judicial Watch in PDF format, mind you. And we're hopeful that Judicial Watch gets their hands on them and shares them for all the world to see. Because Fani was very clearly colluding with the White House, with the Democrats. You want to talk about a racketeering conspiracy? This is it right here. And we're going to get those documents. We can't wait to see them. Shout out to Judicial Watch, my friends, for leading the charge on this. Be sure you're following them. Their website, judicialwatch.org, and grab Tom Fitton's new book, Rights and Freedoms in Peril, to support their amazing work. We'll keep our eye on this case and all the other updates in Faniland. Thanks for subscribing and joining as we do. Now, let's stick with Georgia, because there was a whole separate case that took place today And here it is. Fani Willis gets embarrassed again. How much embarrassment can one county take? Fulton County apparently wants more. They just reelected her. But she just lost and got obliterated. This trial's been going on for ages. And you can see the Daily Mail is reporting, they're even saying it, on embarrassment for Fani Willis. No doubt about it. A co-defendant in the Atlanta trial of Young Thug found not guilty on all charges. Named Diamante Kendrick, known as Yak Gotti, acquitted on murder, racketeering, gang-related charges, a sweeping trial. Young Thug already went free in October. Tons of people accused, and they came out and they say, Mr. Kendrick, you have been found not guilty on all charges. Do you know how much time and money and effort and resources went into this? These people were in jail, and while they were in jail, in Fani's disgusting jails, people were getting stabbed. A defendant here was stabbed as he was awaiting the jury verdict in Fulton County. And the situation is bad, but there was a big victory there. Fani is just embarrassed by this. You can see there were reports from outside the courthouse. Here's what it sounded like after the not guilties. And by the way, prosecutors losing murder trials. Yes, it's Fani, and we know her entire office is a joke. Losing murder trials, it's like losing the Super Bowl. And you should not lose the Super Bowl, okay, if that's the analogy you want to use. Here's what it looked like after the court verdicts. Once we can turn this audio up right now.
Making it mean something and being there for one's children and for one's family. So I'm just so happy, excited for Shannon. I'm happy and excited for his grandmother, who I was able to hug, and I'm happy for his kids, and I'm just very hopeful that this is a turning point and there's great things coming in the future.
Max, is this a fair and just verdict, do you think?
Absolutely. Absolutely. The jurors, we asked so much of the jurors, and they really scrutinized the evidence, and they demanded real evidence, and it wasn't there. And so we are thankful for the jurors, and it's just a great day.
Did you have a chance to talk to the jurors?
I did, and I'm not going to comment on the discussions with the jurors, but I will just say I think the fact that they deliberated for 4 days, and also that just the amount of time that they put in, they certainly scrutinized everything, and they did their jobs as jurors, and we are appreciative of that and so thankful.
Can you reiterate again what he was only found guilty on one charge and what that means for the future, him getting released, all that stuff?
So he was found guilty of possession of a firearm on March 17th, not the day of any of any other crimes. It was the day that he was arrested.
Okay.
And there was a gun that was registered to his girlfriend that was found near the scene of where he was arrested, and that's what he was convicted of. Judge Whitaker, we are so thankful to her for having an open mind. A lot of times when you take a case to trial, you just get the maximum sentence for daring to take on the state. Judge Whitaker did not see it that way. She gave Mr. Stillwell a time-served sentence for the time that he is served.
Good for the fake charge that they had to create because the rest of their case was terrible. So Fani Willis loses another one, and we did not spend a ton of time covering this case, but great news for the defendants in that case, who seemed like they were the victims of more political prosecutions. Fani needed to be this tough-on-crime prosecutor who was riding in to save Georgia. She was doing interviews, writing books, all sorts of insane things, and she went after people who she can't prove a case on. So she lost, and she should be embarrassed about that because these were murder cases that cost probably millions of dollars to the people of Georgia and wasted a ton of time and caused a lot of pain to people who deserve the presumption of innocence. Now, Fani, elsewhere on the day, was fighting back a subpoena battle. A judge today in Georgia heard oral arguments in the Fani battle over subpoenas. Remember that the Senate committee has sent her subpoenas, And now her team is saying that she does not need to show up to comply with these things. Judicial Watch just won and beat her in a records request. Now she's been ordered within 5 days to turn those records over to them. But now she's saying, I don't have to show up in front of the Senate because it's Fani land and she can do whatever she wants all the time with no consequences. Nobody cares. Here's the background before we listen to a bit of the clip, a bit of the exchange. Says a Fulton County Superior Court judge is hearing arguments on this. Does Fani Willis need to testify before the Republican Senate committee in Georgia? There's a committee on investigations that's investigating 2020 and election interference. The accusations stem from her relationship with Nathan Wade, who was appointed to oversee the case and then later resigned. Now, in September, Willis defied the committee subpoenas, refusing to testify or to turn over the documents. She's now faced a legal challenge. She's bringing this claim, saying the subpoenas are invalid. The Senate committee is seeking to question Willis
well,
under
judge
oath
will decide whether Fulton
about
County
her relationship. And Republicans say that her connection to Wade raises ethical concerns about the prosecution of Trump. Now, the judge's ruling could determine whether she must comply. Wade resigned within days. And now let's jump into the hearing because this is what it sounded like today. And so I'll bring us into this. It was happening all day today, so there was a lot of testimony. But I'll bring us into this where this gentleman is saying that Fani Willis's arguments against having to comply with the subpoena, she basically said, first of all, the subpoenas were issued out of order, that it's not actually in session and they can only issue subpoenas in session and they're not in session, so they can't do that unless it's formally within the thing and the closing of the calendar and all. And he just got rid of that. Now he says Fani is saying that the subpoenas are overbroad and that they're asking for privileged information. And here is what his argument is to the judge today.
Petitioner's second fallback argument that the subpoenas are overbroad and seek privileged information. First, as my colleague, Mr. John Fani, pointed out, Petitioner does not address the witness subpoenas whatsoever. There's no argument that the witness subpoenas are overbroad or anything to that effect. So that's done. And in regard to the document subpoena, the problem here is that the petitioner never specifies, well, until today we heard 2 document requests that the 13 that she contends are overbroad. But the petitioner never specifies which requests are overbroad and why, and which ones are not.
Because she doesn't want to give them to you, that's why.
Are privileged. The subpoena is at tab 5 in your binder, but looking at the slide here, we have 13 requests. These requests are not simply asking the petitioner to produce everything or conduct any unreasonable effort to locate documents. They seek documents related to the hiring of the Special Assistant District Attorney.
Nathan Wade.
They seek documents related to the existence of conflicts in the hiring of the Special Assistant District Attorney.
Because they were indicting each other.
And other things of value to and from the Special Assistant District Attorney. Communications with Special District Attorney. Document requests received by the petitioner or her office from the U.S. House Committee on the Judiciary. Communications with the White House, the Department of Justice, the United States Senate, the United States House of Representatives, pertaining to election investigations and prosecutions. The use of federal grant funds and policies.
We want to know all of that.
Implemented in regard to the receipt and use of those funds. Various court filings. And documents related to employment action taken against a witness who alleged the misuse of public funds by the petitioner's office. First, the only case that petitioner cites in support of her argument that the subpoenas seek privileged information must be quashed is the Holbrook versus State case. That case involved a notice to produce in a criminal case. This is, of course, not a criminal case. The subpoenas are issued in a legislative proceeding. Second, the attorney-client privilege clearly could not attach to several of these document requests, such as the district attorney's communications with the White House or the Department of Justice,
Benny Thompson,
the 2020 election investigation and prosecution, and other third-party communications. Those communications were not made for the purpose of giving or getting legal advice, so they're not going to be privileged. Similarly, subpoena documents related to payments to and from the Special Assistant Special Assistant District Attorney, and other things of value that they may have exchanged. Cell phone records.
Yes.
Documents related to that individual's hiring, federal grant funds. Those are not those could not be attorney-client privilege documents under any scenario. So what documents does the petitioner contend are privileged?
Whatever she wants.
Problem again, we don't have a privilege law. The petitioner did not respond to the subpoenas, so we do not know. But to the extent privilege even applies to any of these requests, that privilege is narrowly construed. Again, Your Honor, because we do not know what petitioner contends are privileged, because she did not respond to the subpoena, we don't have the ability to even assess whether they are privileged or not.
Crazy.
Today we heard about the work product doctrine, which is also a creature of the Civil Practice Act. And there, Your Honor, and as you are aware, when there is a work product doctrine question, the court looks at the documents in camera. But we don't have documents. There are no documents to review. And again, that gets back to the problem for a petitioner's non-responsiveness. There's a time and place for a petitioner to assert her privilege if she believes one applies. And that is at the hearing, when she's testifying, and in response to the documents.
30-year-old about turning his life around
All
and
right.
having a second chance.
So sometimes, you know, these news sites, they just start playing videos and stuff when you're not watching them. I don't know why they do that, but they do that. All right, here we are.
Makes very conclusory statements about executive privilege. We didn't hear about that today, and the briefing does not explain why she believes executive privilege is applicable to her or to a legislative subpoena.
Because she's Fani Willis,
Nor the
man.
United States Supreme Court have ever directly addressed the issue of executive
Biggest
privilege
Fani in
the
Georgia.
context of a legislative investigation.
No consequences for anything.
The Mazars case, while it involved congressional subpoena for presidential records, that case did not involve an assertion of executive.
All right, so you can see what's happening there. Some good stuff. We'll see what Fani ultimately does, but what it sounds like is she's just non-responsive. She's not responding to the Senate of Georgia and their subpoenas. She didn't respond to Judicial Watch and their records request, and she lost by default there. Maybe she'll lose by default here. Show up, Fani. Her non-responsiveness is making it difficult for them to even make a claim, make a case. And so if that's the case, Fani can come and explain it at a hearing. So Fani, having a rough day. Of course, we're going to be here continuing to cover this. We certainly hope to see Fani back on the witness stand again, because we know how she did last time when she burst in there into the court with that pink outfit like the Kool-Aid guy. And that didn't go so well for her. But we're looking forward to second round with Fani, and we'll be excited to see you back here when that happens. All right, and so my friends, let's turn our attention over to the Biden pardon, because he's now losing. Hunter loses his final pardon battle. And so let's get into this. Hunter Biden loses the final pardon battle. He wanted his indictment dismissed. We remember the fight over this. His attorney saying, now that daddy pardoned me, everything can go bye-bye. But the government prosecutors, David Weiss, said to the judge, Norika, out of the District Court of Delaware, no. Not so fast. We don't just dismiss indictments for pardons. We terminate the cases so that you can't say that your case was dismissed. You just say it was terminated. It's like a scarlet letter, the little red asterisk, like shifty shift censured. Same thing for Hunter. His case is not dismissed. We'll see what the judge did with it. But let me, before we jump into the filings and the exhibits, a quick update on how devastating this pardon actually is for the Democrats. You can see the Washington Post drop this in their opinion piece. They're still, I think, reconciling the fact that they got lied to directly, repeatedly, and many of them stake their entire reputation on this idea that Joe was not going to pardon Hunter. And this was their key point to distinguish themselves between Trump. Trump is this anti-justice person and they're pro-justice people. And so they follow the normal law and order. But the Washington Post shows just how bad this was. It undermines the Democrats' entire defense of the justice system, saying that Trump is now selecting MAGA loyalists and Biden just gave him cover. They say, to be clear, there was an unquestionable legal right to pardon his son Hunter. The power is massive. The pardon power is extremely broad. But in doing so on Sunday, he maligned the Justice Department and invited Mr. Trump to draw equivalence between the Hunter Biden pardon and any future moves Trump might make against the impartial administration of justice. Right. First of all, Hunter's pardon is without precedent in American history in terms of the size and the scale of the pardon. Trump never did anything remotely close to that. A lot of people are pointing to Jared Kushner's father-in-law or whatever, which is a totally different situation wherein he went to prison. Biden didn't. He was pardoned for a specific crime. He wasn't given a 10-year window where anything goes. But now Biden risks deepening many Americans' suspicion that the justice system is in fact two-tiered, as we've been saying here for several years, because turnabout is fair play. They say Mr. Biden, of course, argues that this is a fairness and says, I believe in the justice system, but no. Biden casually impugns investigators at the IRS, the FBI, career prosecutors, the AG Merrick Garland, a federal judge in Delaware. He maligned all of them, confirming our position on the justice system, which is his. Before Mr. Garland became Attorney General, Biden himself chose him, and he chose to keep David Weiss. It was rigged from the beginning. David Weiss was hand-selected for this. He was the U.S. attorney, and then he got appointed to be the special counsel. They just gave him a different title and said now it's going to be independent. They say the judge did her job by questioning the irregular structure. The plea deal was completely rigged, where one was trying to be tucked into the other, and the judge asked some basic questions about the mechanics of this. All fell apart. Hunter thought it would immunize him from future prosecutions, and it wasn't as explicit as he wanted it to be. Now, the president's sweeping pardon covered any and all federal crimes over the past 10 years, even illegal behavior going back to 2014, 6 years before Joe was president. What? Biden rushed out his pardon on Sunday night to short circuit the sentencing process in both cases in the coming weeks. He had to do it. This averts meaningful accountability. Justice Department guidelines say a pardon shouldn't be issued until 5 years after the sentence is served, but that's just a guideline. And that's also because they don't want a bunch of people sending them letters. All right. You're a grieving mother or somebody who's just seen your son go to prison. Like, I have to get him pardoned, right? Everybody's riled up for the first year. Let me get my son out. This is an injustice. It's really sad. But by 5 years, they know that you'll mostly be accepting and you'll just be kind of petered out. And you're kind of just burned out. 5 years go by. Man, who? She's still calling? Okay, well, yeah, all right. We'll consider it now after 5 years go by. But that's just a guideline because they don't want to take your call. But after that, they'll accept it. Now, that was the case when Bill Clinton pardoned Roger Clinton after the president's brother had served time for cocaine, right? Even Clinton didn't do this. He had already served time. Yeah, they say that Trump granted clemency to Stone and Bannon and Flynn and Charles. And these sent a message that Trump will get his cronies off the hook. No, these were political prosecutions, by the way. That's what the pardon power is for. If this was erroneous, if this was so dishonest and getting cronies off, why did we just reelect President Trump? Why do we do that? Because they weren't what you claim they are. That's what Joe's was. He's not getting reelected at all. These sent the message that Mr. Trump will get his cronies off the hook. Okay, as they say in the article about Biden doing that with his son. Any Democrat who refuses this week to condemn Biden's pardon will have less credibility to criticize Trump. No one should be surprised if Trump invokes the Hunter pardon to justify clemency for many of his allies, including the J6ers. Absolutely. With this one intemperate, selfish act, they say, Biden has undermined, in hindsight, the lofty rationales for his presidency in the first place and indelibly marred the final chapter of his political career. Brutal. All right, so the Washington Post is laying it on thick there. And they're right. Every Democrat, man, who was out there, who ever uttered that line, like these John Harwood fellows and stuff, like, you guys are telling on yourself for not believing Joe. It's like, you guys are telling on yourselves for believing Joe. What kind of judgment do you have? Golly. So here is what ultimately happened. I mentioned at the start, the battle between Hunter and the DOJ over the ultimate disposition. Is this case going to be dismissed like Hunter wants, or is this case going to be terminated like the DOJ wants? And it matters because a dismissal could be for anything. You could say, well, I was dismissed because they didn't have probable cause, because the cop was a liar, they planted evidence, I'm innocent. But terminated, not quite that. Terminated means something else kind of intervened. And you didn't have your case dismissed at all. Daddy came in and saved you. So yesterday, the prosecution objected. He said, you don't get to dismiss anything. Remember the background on this, the way that this broke down out of the docket, to give us a little bit of a refresher here. The courts told us that after the notice was filed, after the pardon came down, Hunter Biden said, here's my notice, and we want to dismiss this case. A motion to dismiss. The government came back and opposed the motion to dismiss the indictment. Then there were a bunch of other filings, and Hunter came back and just responded. He said the following. All right, Your Honor. David Weiss paradoxically claims that Mr. Biden's notice that he just got a pardon from his daddy, he says it's without any legal support, in suggesting that his pardon means the court should dismiss the indictment. But at the same time, he acknowledges that a majority of the courts have chosen to dismiss an indictment. So he says you can't really dismiss it, but you can. That's confusing to me. He says the special counsel's admission that this is the practice of the majority of courts certainly provides legal support to Mr. Biden's claim that dismissal is warranted, not a termination. And I think what happened in the original response from Weiss that we read is that David Weiss's point is that courts can choose, okay? The word is chosen. It's not mandatory. You can decide how to handle this. Now, further undermining Weiss's claim, Hunter's lawyer says, is his reliance upon an argument that has already been rejected. He repeats the very same argument that the government made in the Steve Bannon case, that the court should administratively terminate the case rather than dismiss the indictment. But he acknowledges that the Bannon court rejected that argument and dismissed the indictment as to him. So this court should also reject that and dismiss it as to Hunter. As in Bannon, the pardon here from his daddy comes before the sentencing and before any judgment in the case based on the indictment. And so the appropriate thing for you to do is to dismiss the indictment. We'll see what the judge does. Now, David Weiss's argument in opposing the dismissal of the indictment rests on a non sequitur, that the pardon does not mean that the grand jury's decision should be wiped away. The grand jury indicted him, and that should stand. You don't dismiss the indictment. You let the indictment stand and you terminate the case. The fact that Mr. Biden has been indicted will remain true. We'll always know that that happened, like we'll always know it, even if the indictment is dismissed, just as it would be as if he were acquitted at trial. It is not wiped away as if it never occurred. Neither a dismissal nor an acquittal eliminates the fact of the indictment. They merely reflect that an indictment has been resolved. So the pardon here before sentencing prevents this case from running its course based on the indictment that was filed. So the court should reflect that by dismissing the indictment and indicating accurately that the indictment is dismissed due to the pardon. And it's like, what are we splitting hairs for, Abby Lowell? If, it's all kind of the same thing, what do you care? He wants the indictment dismissed so that Hunter can say, my case was dismissed. That's it. His case was dismissed. He wants to say that in his books, in his public media appearances, and all the things. That's it. Finally, the special counsel, says Abby, that the cover email that he was sent from the pardon attorney with the pardon warrant itself contained an obvious error, suggesting that the pardon would be effective after completion of the sentence. But the pardon itself has no condition, and the pardon attorney has no authority to restrict a pardon granted by the president. And the pardon attorney has since emailed a correction stating, please be advised that the notation of after completion of the sentence was included in error. So Mr. Biden's pardon was effective upon issuance by the president, and this court should respect that decision by dismissing the indictment, as is the relief granted by courts addressing pardons at this moment in the process. Signed by Abby Lowell. They say the special counsel also commits the obvious error of complaining that Biden's legal arguments have been rejected by 11 different judges, counting the judges on the Third Circuit and Ninth, who found they lacked jurisdiction to consider his appeals. So plainly a dismissal based on lack of a jurisdiction is not a rejection of his arguments. So the case should be dismissed, signed by Hunter's lawyer, Abby Lowell, in their final plea to the judge to dismiss the indictment, do not terminate the case. We'll see what she does in a second. But here's that letter from the senior deputy pardon attorney who was over at the DOJ. So he says, wait a minute. Dear Mr. Lowell, please find below the communication. My apologies for the error. We used our traditional form, but hopefully that clarifies the language. The notation of the pardon being effective only after completion of the sentence was included in error. The proper notification can be found below. There are no conditions at all. Our apologies. Please don't hesitate to contact us with any corrections. So Hunter has a valid pardon according to the DOJ. And Hunter's team sent that in to the judge. And so this is what the judge has said. Having reviewed the parties' submissions, and in the absence of binding precedent as to whether it's dismissed or whether it's terminated, and whereas pursuant to the executive grant of clemency signed by President Joe Biden on December 1st, defendant Robert Hunter Biden has been pardoned for the offenses for which the jury rendered a verdict in this case. He was found guilty. And so, it is hereby ordered that all proceedings in this case are hereby terminated. Ordered by Judge Mary Ellen Norica. Yay, baby. So the indictment is not dismissed at all, but the proceedings are hereby terminated. So the indictment stands. Hunter is not going to be able to say, I got my case dismissed. Yeah. Nope. His case was terminated because his daddy pardoned him. So shout out to Judge Mary Ellen Norica for doing the right thing on that, making that final asterisk stand on there. Terminated, Hunter. Your case was not dismissed, so you can't say that. We know that's what you wanted so badly, but you can't have it. Now, meanwhile, his father, our demented president, 82, was led around in Angola. Here's what that looked like.
São atribuídas a figuras da dimensão de Joe Biden, que neste momento está com o presidente da República. E
Okay, I guess he's giving them like $1 billion or something. All right. That's Joe Biden, just pardoned Hunter, and now the Democratic Party is in disarray. Completely undermines their position as the party who cares about the justice system. We know that was always a lie and a scam. They weaponize the justice system for their own ends, and Joe Biden just proved it to us all. But Hunter, not escaping completely unscathed. His case has been terminated. not dismissed, and that will live on indefinitely. All right. And so, my friends, one final update on the day. And then we're going to hear from you and see what you say about all of this. But let's talk some Elon and $50 billion. Elon Musk got robbed of $50 billion from a Delaware judge. We know this is not about stockholders' rights and equal shares and making sure that the minority shareholders are properly represented or any of that garbage. It's about tying up $50 billion from one of the most productive people ever to exist on the planet. And Tesla, in the midst of this ruling, is promising to fight back. They've said the following: a Delaware judge just overruled a supermajority of shareholders who actually own Tesla and who voted twice to pay Elon what he's worth, $50 billion. The court's decision is wrong, and we're going to appeal. This ruling, if not overturned, mean that judges and plaintiff lawyers run Delaware companies rather than their own rightful owners, the shareholders. And so I've got the full opinion. We'll take a look at it. It's a big fat one, and you can see over 100 pages, 103 total pages. We'll hit the highlights, but a little bit more background on this from the New York Times. Now that he is going to be appealing this, what comes next? We'll come back for that on that. But here's more, because Elon and Vivek are going to be going to the Capitol this week on Thursday to talk about achieving regulatory rescissions and administrative reductions and more. This is from Speaker Mike Johnson. The Doge Committee now has a logo, and it's the Shibu. It's the Shibu Inu? The Doge? Oh my goodness. Department of Government Efficiency. It's happening, GIF. It's happening. Elon Musk and Vivek Ramaswamy going to be there December 5th, 2024. Time and location details will be sent separately. And so this is why they want to tie up $50 billion, because Elon is going to come and cut a bunch of that money. So let me show you what the opinion looks like, and then we'll see what is coming next. But this was what came down from the judge. They say, all right, out of Delaware, this decision marks the trial level denouement in a derivative suit asserting fiduciary challenges to the largest executive compensation award in the history of public markets, Tesla's award to Elon for $50 billion. In January of this year, the court issued a post-trial opinion finding that the award was subject to review under the entire fairness standard. The defendants bore the burden of proving the entire fairness, and they failed to meet their burden. And therefore, the plaintiff is entitled to rescission, which means that the minority shareholder who sued said Elon's compensation is too much money for him. He doesn't get it. The plaintiff's attorney then petitioned for fees and expenses, which is atypical in a derivative lawsuit when they win. Atypically for this court, though, Tesla responded by putting the rescinded compensation plan, the exact same plan, to a stockholder vote for the purpose of ratifying it. Then they moved to revise the post-trial opinion, asking the court to flip it. And so now we're going to give new fees. Now the motion to revise is denied. The large and talented group of defense firms got creative with the ratification argument, but their unprecedented theories go against multiple strains of settled law. There are 4 fatal flaws that are listed there. And so the fee petition is granted in part. The plaintiff's attorneys asked, this is what the people suing Tesla wanted. They wanted $5.6 billion in tradable Tesla shares. It's a ransack of the company. In a case about excessive compensation, the judge says, well, that was a pretty bold ask. In other words, they're suing Elon because he makes too much money. $50 billion was too much for Elon. But $5.6 billion is good enough for the lawyers who are suing Elon to steal part of his hard-earned money. In my opinion, that's what they're doing. Now, to be sure, their methodology for calculating this figure is sound. Delaware courts award fees based on a percentage of the value of the benefit achieved. Applying this approach to $55.8 billion is a big figure. But the fee here must yield. $5.6 billion is a windfall, no matter the methodology. And so what we're going to do is we're going to give 15% of the total award. So they're going to give these lawyers $345 million. And they say that Tesla may elect to pay them in cash or shares. It's sick. They're just going to take the company because that's the cost of this litigation. So here's the factual background. It draws from multiple sources, says the judge. Portions come from the post-trial opinion, which she already wrote for us. Other is from testimony, but here's what she wrote. On January 21st, the Tesla board held a meeting and they granted Elon Musk a grant. 12 tranches, each of which would be vested upon certain milestones. Each tranche provided Musk options to purchase shares equal to 1% of their common shares. Fully vested, Elon gets 20 million shares. Then a stock split happens. Then we get 303 million shares. Then there's a proxy statement. Then to approve all of this, they do some things. Then they add this person to the share reserve. Then there's 400 million here. Tesla achieved all of it. Okay, so Elon, all of this stuff happens. Tesla, guess what? They got all of their milestones completed. Nearly all operational milestones achieved. Elon's insane, right? Guy's like a machine. By April 2022, 11 of the 12 had vested. And of June 30th, all conditions for the final had vested as well. All options were fully vested and in the money. Musk never exercised the options, though. So then this guy, Tesla stockholder called Richard Tornetta, filed this action. He says, what? That's not fair. He sued Musk and Tesla, and he claimed that Elon breached his fiduciary duties. Then he got extremely capable lawyers. And I mean, this was I would imagine they found a stockholder to sue and they're going to make $300 million. To understate matters, their litigation efforts were substantial. They conducted pre-suit investigations. They prepared and filed the complaint. They overcame a motion to dismiss. So now she's puffing up their numbers like the plaintiff's lawyers. This judge, watch what happens when she retires. Let's see where she goes. The matter was fully submitted. The parties, okay, this is what the lawyers did all of this. That's why they're worth $345 million. Sick. So the court then ordered rescission. The plaintiffs achieved a total victory. They said it was unfair. The court did not find that the board should have paid Musk nothing. There were a lot of different amounts of money that the board could have decided to pay Musk. Instead, the board capitulated to Musk's terms and then failed to prove that the terms were fair. The court did not declare that the legal authorities control. But the mechanics, there was a rescission. And so the judge just says, the stockholder vote, less than an hour after the court issued an opinion, Musk went on social media. 7 hours later, Musk declared that Tesla would move for another vote. Then the board took another vote. They reviewed a bunch of documents and they say that they're going to try to evade your judgment in Delaware. So they filed 4 emergency motions saying, you can't do this. You can't override this. Then they filed a proxy statement. Tesla stockholders voted in favor of this. Musk declared victory before the polls even closed. The Tesla shareholders at the annual meeting says, yeah, definitely. On the day it filed its proxy statement, then Tesla lawyered up, adding 5 law firms to the list of attorneys already representing this. Like this isn't about one dude's stock. This is a group of trial lawyers trying to take down Elon, and they're using this dude's shares to do it. On June 28th, the director filed a motion to revise. The court bifurcated this into some other legal things. And so then they're going to give us arguments, right? And so it's 100 plus, 90 plus pages from there. So that's the thesis of what's happening here. So Elon has lost this. Here's the background from the New York Times. They say, will he ever collect now? He's been on a winning streak for a while, but this has not worked out for him. The compensation plan at the last vote, the judge failed to mention this in her opinion, passed by 72% of Tesla. The wide support suggested that the automaker's shareholders believed that the company's fortunes were tied to Elon. Now, they said that they're going to appeal this decision, and the board could draft a new pay deal under the jurisdiction of Texas, where the companies have now moved, but there would be a big accounting hit on that. And Lipton, some law professor, says Elon's not going to win, but we'll see. Now, McCormick denied a request for $5.6 billion in legal fees, and it's sick what they've done. Here was a great article from this individual called Professor Bainbridge, and he did the math for us because you know how much we hate that here. He says, McCormick's latest opinion continues the trend of the courts controlling the companies. The plaintiffs' lawyers, the people who sued, were granted $345 million, which is an insane number. I don't care how much work they did. Admittedly, she slashed their original request, which was $5.6 billion in fees. Right? So some very smart lawyers just got together. They said, this case is worth this. Let's sue in Delaware. She called it a bold ask, even though it was insane. It's theft of a company, in my opinion. I mean, they didn't earn that. McCormick then rejects the idea that the fees should have any remote resemblance to the numbers of hours they worked. But the opinion acknowledges that they claim they worked 20,000 hours. So if they worked 20,000 hours and they get $345 million, that's $17,000 an hour. That's good money, which strikes this observer as being at least as offensive as Musk's allegedly excessive compensation. After all, unlike litigators, at least Musk actually makes something that's useful. Not like these trial lawyers who just sue and try to steal other people's hard-earned money. So Elon Musk is going to be fighting back. These are people who are trying to destroy him because he's going to be in the Doge administration now and will be here to see where this case goes. Hopefully Elon's appeal resonates with some more capable judges who are not acting like little dictator communists trying to undermine the will of the actual shareholders of Tesla to enrich her trial lawyer friends. We'll be here continuing to cover this, my friends. Thank you for subscribing and joining us as we do. All right, my friends, it's been a beautiful, beautiful stream today. Thank you so much for joining us and sending in these incredible chats. If you are just joining us and you want a quick recap, we hit some good stuff today. Fani Willis has been ordered to produce business records related to the January 6th case and Jack Smith within 5 days to Judicial Watch, and we're going to be here waiting for those docs to drop. She also got embarrassed as she lost other cases in the YSL case, and she has to now possibly face a subpoena that is going to be coming from the Senate in Georgia to her office. And we'll see if she's going to be testifying a second time. We certainly hope so. Then we talked about Biden and how in the final pardon battle, his case was terminated, not dismissed. His attorneys were pleading with the judge, please dismiss this case, please, 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 so that they could say his case was dismissed, but it was not dismissed. It was just terminated. Sucks for him. And then, of course, we saw Joe Biden being held around by the president of Angola because he's not a competent, capable person any longer. Doge is coming to the Capitol this Thursday, and we're excited about it, my friends. We're on team government efficiency, maximum efficiency, and we're excited for that. And so now, my friends, it's time to hear from you. Let's see what you say about this. It's so great to have you here. Thanks for stopping by today and joining us as we uncover all of this. As a reminder, we also have a members-only community. We do live streams in the morning. We already had a full live stream today before we started this one. And with our membos on locals, we stick around for our members-only after party. And we'd love to see you come and join us over there, watchingthewatchers.locals.com. But we got some donos that came in, my friends. Thank you so much for sending these in. And I see a couple of these. Hey, what's up, Tony Hay Munkets in the house? Tony Hay, and thank you, Donut. Donut's clipping for us on the day. Bringing in 5 membos. Gary Sukamura in the house. What's up, Gary? Welcome. James German, Brimstone DD, Paul Allen's in the house, and Kevin Murphy gifted membos courtesy of Tony Hay Munkets. Thank you, Tony Hay. Plus, Jason Pocaro is coming in. What's up, James Anderson in the house? Thank you, James Anderson. For the poop emoji. I know, stinky. Golden Gaming says, like and share this video with friends and family. Get Rob out there all across the tubes. Thank you, Golden Gaming, for that. Yeah, I would really appreciate that. Yeah, if you have a friend or family member, if they're watching some reality TV show or something, you say, get that garbage out of your head. Have some of this garbage instead. It's the Rob Gouveia Show. Check it out. Thank you for that, Golden Gaming. Hey, Sergi P. Rob, are you going to do merch again? If so, I have a suggestion with who? Bunker Branding Co. from Demolition Ranch. Matt does merch for a lot of YouTubers. Possibly. Yeah, possibly, Sergi. You know, I don't know that anybody's that interested in merch from us, to be honest with you. But sounds like if you have a good, high-quality company that makes it kind of turnkey, that would be a good solution. But thank you, Sergi. I appreciate the recommendation. Teflon Don. Teflon Don says, Fanny Pack has that Tiffany Heinyard syndrome. I don't know what that is, but it sounds nasty. Queen Bee's Art Hive says, I love my Watcher family. Me too, Queen Bees. Rob, you rock. Thank you. Thank you, Queen Bee's Art Hive. Thank you. We love you back. You're the best. Thanks for saying that. Thanks for being a membo for 13 months. Teflon Don, you're out of order, trustee. You're out of order from Teflon Don. Sheila Pooh says, love that Fanny is falling on her face everywhere. Yeah, she had a rough day today. Judicial Watch, Senate Committee subpoena, and the YSL case. Rough. Couldn't have happened to a nicer person. Teflon Don says Mortal Kombat is Fanny Pack Willis versus Tiffany Hinyard. I still don't know who that is. Who is that? Why am I missing that one? Oh, is she the prosecutor on the YSL case? Oh, no, she's the mayor. She's the mayor. Okay. Is that who you're talking? Henyard. Yeah, okay. So she's the mayor. Yes, that's hysterical. Is she still the mayor? Gosh, yeah. Tiffany Henyard. Yeah, the mayor. I'm trying to grab a photo. Yeah, lots of complications to Tiffany Henyard, if you missed it. Anyway, so thanks for that. Teflon Don. Sheila the Pooh, great to see you. 1,000,000 hugs to you, Sheila. Look at this. We got 10 membos coming in, courtesy of Sheila. We got Demon J, welcome. Beachy Queen, Notes is here. Sue, welcome. Debbie Burgess, Rizzy, AK Robbie, Tisha Sutton, Della Sandor, and JF Foster in the house. Gifted membos, courtesy of Sheila Pooh. Thank you, Sheila. We got Teflon Don says, Fanny Pack, where is that watch? Pay back that taxpayer money. Make sure you wear the orange jumpsuit backwards. From Teflon Don in the house. Hey, Sheila Pooh says, welcome to new membos. Thank you, Sheila, for bringing them in. Hit that like button. Share this channel. Watching the Watcher fam is the best. I know. And Flex Abel says, you're the best and generous with the fam, Sheila Pooh. He's right. Felix Abel is right. You're right. Very generous. We love you, Sheila. Thanks for bringing so many new friends in. And new friends, welcome aboard. This old guy says, hasn't Fanny worn out the claim that she wasn't served? Seems like that's the only thing she might have actually learned in law school. Yeah, it's like, in Fulton County, what do they teach? How to avoid service 101. Great. Great job. Hey, Audie Joe is in the house. What's up, Audie Joe? Look at this, 20 membos, Audie Joe. Audie, you're not even a membo, but you're bringing in 20 membos. What a selfless person you are. Synthetic Future Entertainment's coming in. Debbie Prescott is here. Gail Gelford. What's up, Jerry Last, Jonathan Gary. We got Freedom for Evar, JM Farouch. We got William Ingram. Just Me's here. What's up, Space Debris? Tony Hay Munkets shouting out. Clayton Tower, Linden Lady. Tim Doyle Music. We got John Trotter, Dee Meng Zhang, Time for Change. Beth Amphetamines. What's up, Beth? Beth Amphetamines. Man, I'm sure you're a good time, aren't you? Deborah Brendan, Echo Streaming. We're hanging out with Beth Amphetamines tonight. Oh my God, that's going to be a wild time, isn't it? Hey, C. Reed is here. Yeah. No one is above the law. Thank you, C. Reed. Joe Biden posted, no one's above the law. Community notes say, your son is. You just pardoned him. You made him so. Funny. Uncle Bozy, I'm not surprised about the Hunter Biden pardon, but I'm very concerned about possible pardons for other members of the deep state and the Biden family. Yeah, I'm with you on that, especially people like Newland, Vindman, Milley, Brennan. Brennan's a big one. Jake Sullivan, dozens more, who may have committed serious crimes against the U.S. Yeah, Blinken you'd put in there. Mayorkas you'd put in there. I don't want revenge or retribution, but I do want justice and real repercussions for wrongdoers. There has to be serious consequences for corrupt behavior in the future. I'm with you on that, Uncle Bozy. I think Hunter is just a small pawn. He's a peon of a much bigger operation. But yeah, guys like Brennan, John Brennan, is one of the worst in the country. He's been doing this for years. He tried to rig 16, 20, and 24 and was utilizing the CIA to do it. Like those guys, oh yeah, there should be, Fauci, like those, like he's going to pardon Fauci or something. Yeah, we want repercussions. It's not retribution. It's justice, although justice has a retributive feature to it. So, yeah. Rick Donner, what's up? Well, this is interesting. Number of pages of regulations added to the Federal Register each year since 1936 to 2011. What the hell happened in 1970, man? What happened in 1970? 1972, I think, right? Interesting. It's like the inflation of everything. Once you get off the gold standard, everything inflates, even regulations. Hallie P. Both Shannon and Jack have been staffed in custody and are pending the results of the altercation before they're able to be released. It's disgusting. And who are we talking about? Shannon and Jack? Hallie P, are we talking about the co-defendants in the YSL case? What else do we talk about today? Thank you, Hallie P. I appreciate it. When people are unnecessarily in custody, it is disgusting. We got this one from Sheila Poo. Law RN, welcome. Subscribe Butter is here. Lovely Soul, Yeller Mustard, and Betsy in the house, courtesy of Sheila Poo. More from Sheila. Thank you, Sheila. A million hugs to you. Yes, voice of the people. Tiffany Henyard is the super mayor of Dalton, Illinois, under investigation for stealing funds. Yeah, that is a wild case. And she's been indicted, right? I think a couple times under investigation. She's not giving up power. Funny story. All right, Rick D. Gifted membos to Just Cause, who's modding the fort down for us. Jeffrey Phillips, Egyptian Princess, Grouchy Mama Bear, and Snark. Gifted membos. Thank you, Rick D, for doing that. Welcome, new friends. And Super String X. What's up, Super String X? Thanks for hitting the support button, joining up. Grab the members only stream from this morning. We do member streams in the mornings for our members, and we do them in the mornings. So come and join us, watching thewatchers.locals.com or on YouTube. And thanks, Superstring, for supporting us by becoming a member. All right, and so let's check what's happening on X, my friends. Then we'll wrap it up on the day and head on over to Locals to debrief there for a bit. We do have a couple of comments here. Hey, Norman Lee Smith Music. What's up, Norman Lee Smith Music? You guys should check out his music. Says, thank you, Rob, for the update and the analysis. Things just seem to be getting better and better. What a difference an election makes. Here's the latest release from Norman Lee Smith Music on Apple Music and submitted for your listening pleasure. Well, that sounds like a good one, Norman Lee Smith. Let's see here. Let's see. I'm not logged into Spotify. Dang it. All right, it's not working. All right. Wait, is this going to work? Let me see. Checkmate to the deep state. This is Two Hearts, One Life. Is this going to play? It's not going to play. Dang it. All right, I'll have to log in next time. Sorry about that, Norman. Thought I was going to figure it out real quick. Hey, Fred says, Rob, if you didn't see it, Natalie Merchant sued Fani over FOIA, and the case was live. The person in charge of records took the stand and was one of the nastiest people you'll ever see. Oh, yeah, I think I did that. Yeah. Maybe Ashley Merchant sued? He was telling Ashley that he hated her and he didn't respect her in court. Yeah, that was nasty. I did remember that. They didn't really make any good findings. It was just kind of a bloodbath in court that day. So, my friends, check out Norman Lee Smith music. If you're on Spotify right now, Norman Lee Smith music. Or if you're on Apple, check it out. And get some good tunes. Vibe it out tonight. All right, so my friends on X, thanks for following us on X. Okay, yeah. So Hallie P says, yeah, Shannon and Yak. Yes, YSL case. Sorry, they were stabbed. Thank you, Hallie, for correcting us on that. Yeah, we didn't pay too much attention to that case, but I know that there were a ton of people involved. So Shannon and Yak, 2 people stabbed. And we did cover the Fulton County jails and prisons and how they were found to basically be violating people's constitutional rights because the conditions were so bad. So we've got people who were acquitted, who deserve the presumption of innocence, who were ultimately determined to be innocent, but nonetheless were incarcerated and stabbed. That's justice in America. Thank you, Fani Willis, for that. Are they going to get their time back? No. Are they going to get that pain and suffering back? No. Maybe they'll sue and get some money and they'll settle with them, but I doubt it. It's Fulton. Thank you, Hallie P. They were not convicted and sentenced to be stabbed, so they shouldn't have been stabbed. And if you're going to take somebody into custody, you have to make sure that they, at least do your best to make sure that people don't get stabbed. It's like when you watch a child, you don't let the child play with fire. You have responsibility for that child because you're the adult. When you are acting as the custodian of another human and you don't give them the means to defend themselves, you cannot let them get stabbed and eaten to death by bedbugs because that's inhumane. And our founders wrote that into our Constitution. You can't do that, Fanny. Rick D says Henyard is under federal investigation but hasn't been charged yet, though one of her advisors has been indicted. Okay. I was going to say, if she had been indicted, we probably would have covered it. Like, has she been indicted? I don't think so. But weren't they trying to lock her out? Like they were canceling, I think the town council canceled her credit cards or something. She was spending. It's a great story. Okay, maybe we'll do a segment on that. Thank you, Rick D. And this one came in. Rick D. Uncle Bozy says, this is Fanny and Nathan on their cruise. I guess. What is this? This is Tom Selleck? Who is this? I don't even know who these people are. What does this mean? I don't know. Did they also steal $700,000 from taxpayers? Is that what that is? I don't know who that is. All right. Oh, it's too funny. Okay, so that came in from Uncle Bozy. Thank you, Uncle Bozy. I clearly have no idea what that is. Fanny and Nathan on their cruise. Someone's got to fill me in. All right. My friends, it has been a hilarious and very fun stream. I'm very grateful to spend the time together with you. Thanks for being here and for joining us. I want to shout out our mods. What's up, Donut Mind? Me in the house. Playing Hooky was here. I think I saw Just Cause in the house, became a membo. We had K-Bean, Carrie B clipping for us today and, of course, this morning. And we're grateful for all of that. We're going over to watchingthewatchers.locals.com, our members-only community. We'd love to have you come and join us over there. But if we don't see you over there, well, I hope to see you back here tomorrow because we are going to be back here and we're going to get into it again. And in order to do that appropriately, we're going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.